all of us at Central University and to our listening publics. We are a private university, but that does not mean us and our students are exposed to current knowledge both in and out of the classroom. And that is why we are going to continue to pursue these agendas for public lectures which relate to matters, topical matters, and matters of interest. I accept to chair this event, and I look forward to the lecture, and I look forward to introducing our speaker properly very soon. So, thank you very much.
Ladies and gentlemen, at this stage, I would like to acknowledge the presence of the chairperson of Central University Council, the person of Mrs. Florence Akuffo. Give her a big hand. We will take a short interlude, and then the program will continue. Musical interlude. You can give us the university anthem. If you are not ready with the interlude, I'd like to ask the acting dean of the Faculty of Law, Dr. Josiah Hansen, to give us an introduction for the Faculty of Law. Thank you very much.
Thank you. Professor Chair, Your Ladyship, Justice Sophia Akuffo, retired Justice of the Supreme Court of Ghana and former Chief Justice of Ghana, the Pro Vice Chancellor, who is our MC, Professor John Fosu Enim, the Chair of Council, Madam Hashru, Deans of Central University, Deans affiliated to the Conference of Law Deans in Ghana, distinguished ladies and gentlemen, all protocols observed. I warmly welcome you all to this evening's public lecture in this state-of-the-art auditorium. In recent times, Central University, and indeed the Faculty of Law, have set out to engage with the general public in a series of public lectures to enhance knowledge and understanding of the law amongst the citizenry, and also appreciate the social legal implications that may arise thereof. It is on this basis that this maiden lecture of a series of planned public lectures, dubbed Reflections on the Law, has been organized, and we are really humbled and feel privileged to have Her Ladyship, Justice Sophia Akuffo, here with us to speak on the topic enforcement of human rights in Africa. Your Ladyship, you are indeed very welcome, and we are grateful honoring our invitation. At this point, I would like to give you a very little insight into who we really are as a Faculty of Law of Central University. The Faculty of Law of Central University was established in 2014 and has since then made huge and significant strides towards the delivery of quality legal education in Ghana under the Bachelor of Laws LLB program. As a faculty within the largest private university in Ghana, we have always been aware of our responsibility to ensure that our law graduates become transformational leaders imbued with integrity and Christian values and who will make a positive impact in this country and beyond. I can assure you that we do exactly just that. Through the leadership of the founding dean, Professor Ken Akuffo, followed by Reverend Professor Sophia and myself, the Faculty of Law has over the last 8 years moved from strength to strength in its achievements. Supported by a formidable team of lecturers consisting of full-time and adjuncts at each of our 3 campuses, we can boast of a mixed blend of legal practitioners and academics, all of whom have a minimum of an LLM degree in law. The excellent efforts of our lecturers are complemented by the hard work our students put into their studies during their 3 or 4 years of study with us, which is then capped in their final year with the preparatory classes we organize to increase your chances of passing the entrance exam into the law school. As the Dean of the Faculty of Law, I am proud to admit that the collective efforts of management, lecturers, administrative staff, and the students themselves have resulted in a significant number of our law students gaining admission to the Ghana School of Law. To this great achievement, I wish to say ayiko to all of you who have contributed to this. As part of our continued efforts to be at the forefront in the provision of quality legal education in Ghana, we wish to announce to the whole of Ghana that we have recently been granted accreditation by the Ghana Tertiary Education Commission, GTEC, to run the Diploma in Law, which is a 2-year program, and the Diploma in Paralegal Studies, an 18-month program, both of which will take off in February 2023. We are also far advanced in our plans to commence a number of LLM programs in law, and I must say that all of this is to the glory of God. On a final note, the Faculty of Law will, in 2 years' time, that is 2024, be 10 years old. As a result of this, a number of activities are being planned to celebrate this milestone. And there will be a number of public announcements to that effect nearer the time. So kindly watch the space. I thank you.
Thank you very much, the Acting Dean of Faculty of Law. At this stage, I would like to call upon the Chairman to introduce our speaker for this evening's program, Professor Sophia.
Dean Law, that was excellent. Thank you. We will be watching the space. Thank you very much. It gives me great pleasure this evening to introduce our very special speaker. I will go by the script, Your Ladyship, and then when I finish going by the script, I will go off script. But it will be a very kind off script. This lecture is to be presented by Her Ladyship, Justice Sophia A.B. Akuffo, former Chief Justice of the Republic of Ghana. Justice Akuffo was born on the 20th of December 1949. She received her secondary school education at Parliament Hill School in Hampstead, London, and Wesley Girls High School here in Ghana. Off script, if you put Hampstead Hill, Parliament Hill, Hampstead in London, and Wesley Girls together, what else do you expect? She holds an LLB degree from the Faculty of Law, University of Ghana, an LLM degree from Harvard Law School, Cambridge, Massachusetts. After qualifying as a barrister of law in Ghana in 1975, she performed national service at the Legal and Consular Section of the Ministry of Foreign Affairs. Thereafter, she worked with the law firms U.V. Campbell & Co. and W.E. Fugger & Co. She then joined Ghana Airways as a legal officer and Deputy Corporation Secretary from 1979 to 1982. She then worked with Mobile Ghana, where she functioned as legal and relations manager and company secretary for the company, which included Mobile Sierra Leone and Mobile Liberia from 1982 to 1992. She established her private law firm, Akuffo Legal Consultancy, now Apex Law Consult, and practiced as legal consultant from 1992 to November 1995, when she was elevated to the Supreme Court bench. Off script, I remember hearing her say about that elevation, that she wondered what it was that the president at the time saw. But what was seen, indeed, we see today. In February 2006, she was elected as one of the pioneering judges of the African Court on Human and People's Rights, and was sworn in with other members of the court in July 2006. She was elected the Vice President of the court for a term of 2 years in September 2008 and again in 2010, elected President of the court in September 2012 for such a term of 2 years, after which in 2014 she completed a term as judge of the court. She has held various positions on various boards, commissions, and committees over the years, both in Ghana and in the African Union. She became the Chief Justice of the Republic of Ghana 2017 to 2019. She is currently Chairperson of the COVID-19 National Trust Fund. Madam, we are deeply grateful that you could make it today. Off script, it is an honor tonight to welcome Her Ladyship to this auditorium. I recall in 2017, May 26 to be precise, I was a quaking aspirant to a role, and I entered the interview room. I was to be interviewed for the position of Vice Chancellor of Central University. Lo and behold, in the chair was none other than Her Ladyship Justice Sophia Akuffo. She was with other very seasoned and senior people, including Professor Akila Basore, Dr. Norte, and none other than our own Chair of Council, Madam Florence Ashford. I don't know whether I've done a good job since then to now, but Madam, I thank you so much for the very engaging interaction we had on on that day in May 2017. I recall those days, those hours very, very keenly. Thank you. I do hope that posterity will say that you took the right decision. Further off script, Madam, Her Ladyship, Justice Akuffo, was a member also of the Council of Central University. The Dean just mentioned a couple of programs that have now received accreditation by the Tertiary Commission. Indeed, these were championed by the Ladyship, Madam Justice Sophia. She championed them in those days, and I recall virtually every meeting we had, it was like, you have to have paralegal studies, you have to have paralegal, you have to have paralegal studies. We took it, and today, as you say, from February, these will be run. Your Ladyship, thank you very much. It is always important that senior people speak the word and ensure that the younger ones take these and run with them. Audience, it is a privilege to have stepping up to speak with us, Her Ladyship, Justice Sophia Akuffo.
That have already been established, and we'll go straight to my lecture. But before I do that, I would like to thank the Faculty of Law, Central University, for inviting me to present this lecture. As I told Madam Hatchford, Susie is my daughter, and when she asks, I can hardly say no. But also, I have very close relationship, not only with the university itself, but also with the owner of the university, the International Central Church. So, one way or the other, I was compelled to accept the invitation. It formed the topic, enforcement of human rights in Africa, to be quite a very, very, very broad topic. And as far as I'm concerned, it can be a whole course, purely focused on enforcement of human rights in Africa. So I decided that instead of spending too much time on the enforcement, which would mean case law and so on and so forth, I would rather give an overview, because in my experience, I realized that a lot of people, including those who are legal practitioners or even teachers of the law and students of the law, are not necessarily that familiar with the African Union structure that has been set up through the auspices of the African Union concerning human rights on the continent. So I will go over briefly the framework, I call it the African Union Human Rights Framework, and speak about the various normative standards and instruments that guide and guard and govern human rights enforcement in Africa. And then I will also touch briefly on the regional arrangements that result from this inspiration from the African Union, and then bring it down to the domestic level where enforcement is really supposed to be taking place. I will also mention the African Court of Human and People's Rights, which is the mechanism that is established within the African Union system for enforcement, particularly of the African Charter on Human and People's Rights, but really also of every international instrument or standard on human rights to which member states are party. I'll start off in my view, or expressing my view that human rights are God-given. Nobody gives anybody their human right. You're a human being, and therefore coming into this world, you came with your body of rights. So when we talk about African human rights or international human rights, we're not talking about anything. We're just talking about standards that are applicable to every human being and are innate to the fact of being a human entity living on this earth. So human rights are not given by another person, whether individual, whether a government, whether an institution. So don't ever feel somebody has given you your rights. Your rights came from God. At best, human beings and human institutions simply acknowledge something which is pre-existing and they declare that it is. That is why the most important human rights instrument, or the most important human rights set of standards in the international scheme of things, being within the United Nations itself. It is not a United Nations Convention on Human Rights, rather it is a United Nations Universal Declaration of Human Rights. They could only declare it. Now, I'll wax a little philosophical and say that it is through law, and by law I mean standards, rules, regulations, that states, as well as groups and societies, and for that matter, even in a domestic setup. That's how we organize ourselves for success. Every human organization presupposes that there are certain sets of laws of governance so that everybody knows how things are supposed to work. Because you can't have governance without law. And if people, or two or more self-determining states, agree to join forces in the pursuit of mutual peace and development, there is the need for ground rules that will assure an enabling environment. Now, over the years and over the centuries, I will not go back to centuries-old philosophies and theories, but over centuries and decades, culminating in the second half of the 20th century, it became a broadly accepted norm that one, democracies are better enablers of peace and development than dictatorships, anarchy, or tyrannies. As Mr. Churchill is reputed to have said, democracy is the most confusing human institution, but we have not been able to invent anything better. It's for us to try and work with it. The second principle or norm is that democracies are nothing unless fundamental human rights are respected and protected by nations and amongst people, whether formally in the form of bills of rights, constitutional provisions, enactments, or something like the Universal Declaration of Human Rights, or informally in the form of common standards of behavior and standards. And most of our interaction with each other are also based on such common standards of behavior. And then mechanisms for application and enforcement of human rights are sine qua non for assurance, sustenance, and strengthening of democracy. If you do not set up or create methodologies and mechanisms to enable the application of human rights, you're lost. You have it, you say it's there, but if no one knows and no one is enforcing it, these are just words. And it is based on these recognitions that at the meeting of the General Assembly of the United Nations in 1948, December, in Paris, the Universal Declaration of Human Rights was proclaimed. So I'm not saying enacted, they pre-exist, so they were simply proclaimed. Some call this the mother of human rights, but it was just the mother of declaration and universal acceptance of human rights. And it has become a basis and the litmus test for human rights law and standards across the globe. And from that time, whether the Committee of Nations considers any member state or any country or any organization to be a respecter of human rights, that is determined by the extent to which, and that because the UDHR, being the Declaration of Human Rights, sets the basic principles. If you fall below it, you're not a democratic country. You're not a country that respects human rights. Now in Africa, the UDHR is the founding base of the African Charter, of the African Union norms established through the African Charter, human rights. Maybe somebody might ask me later on what are people's rights as distinct from human rights. I will not go into that right now. I will just do a quick overview of African Union normative framework. The OAU, which was the precursor of African Union in 1981, adopted the African Charter and rights. And it entered into force in 1986. As at now, every single country, Africa, by the 55 states, Africa, have not only signed, have ratified Charter. It's one of the universal charters within Africa. Now, the OAU Charter itself declared certain principles when it was establishing the existence of the African Union. That came into being by a charter as well. And the it stipulates that freedom, equality, justice, and dignity are essential objectives for the achievement of the legitimate aspirations of the African people. So the African Charter on Human and People's Rights, which then put together in systemic, deals with basic things like the individual right to equal to every other person, for the law and to be entitled to equal protection for the law. Everyone has the right to be respected and to even they are due as human beings. Every individual has the right to liberty and to the security of his person, so you can't deprive them of freedom of movement, of their lives without any process. They have the right to have their cause heard by known processes, and it's the duty, and it also declared that it's the duty of the state to ensure elimination of all forms of discrimination. And then every individual has the right to work under equitable and satisfactory conditions. So to ensure the protection of these rights, the Charter itself, the African Charter on Human and People's Rights, also in part 2 set up the African Commission on Human and People's Rights. And its mandate is to protect and promote. Unfortunately, the protection and promotion mandate did not include enforcement or even interpretation. So the African Commission on Human and People's Rights, most people call it the Bantu Commission because it's headquartered in Bantu. It does not have judicial powers. It makes recommendations to the summit of the heads of states of the African Union, and between you and I, they can choose whether they will follow it or not. Now, I come to another the normative structure, a constitutive act of the African Union, which is what changed the institution from Organization of African Unity to the African Union. It also continues in the spirit of the OAU and establishes the union. We are supposed to be gradually evolving into a United States of Africa. That's another subject for another date. But the Constitutive Act sets out the objectives of the AU, among others, to encourage international cooperation, taking into account the United Nations Charter, the Universal Declaration of Human Rights, as well as to promote and protect human and people's rights in accordance with the African Charter. So the African Charter also sits at the center of the Constitutive Act of the African Union. And it then goes on to set up some rather elaborate guiding principles of the African Union, which include the respect for democratic principles, human rights, the rule of law, and good governance. And really, once again, human rights, in my view, sits in the middle of all these principles, because without respect and protection of human rights, how are you going to have good governance? How are you going to have viable democracy? How are you going to have rule of law? There are other continental instruments that have a bearing on the protection of human and people's rights across Africa. There's the African Charter on the rights and welfare of the child. There's the protocol to the African Charter of Human and People's Rights, which establishes the African Court on Human and People's Rights as a judicial body to interpret and apply the Charter for enforcement. There's also the protocol to the African Charter on Human and People's Rights on the rights of women in Africa. Now, women are human and women are people, but it was deemed necessary to focus on certain gender-based issues that will properly address the concerns of and the needs of women. And so that's why there is the Women's Charter. And then there is the African Youth Charter. There's even an African Charter on the agent. There's the OAU Convention governing specific aspects of refugee problems in Africa. Many times we forget that refugeeism also raises a lot of human rights issues. And when we are talking about human rights, we must never forget about refugees. All these continental instruments, in one way or the other, make provisions for the protection of rights and are all offshoots of the Universal Declaration of Human Rights. Now, as I've already said, the African Charter on the African Court on Human and People's Rights was created by a protocol to the African Charter on Human and People's Rights when they realized the need for a judicial mechanism for the enforcement of not only the African Charter, but of all the instruments that deal with human rights. And it's interesting, I will quote Article 3 of the protocol, the court protocol as we call it, which sets up the jurisdiction of the court to interpret and apply the Charter and any other relevant human rights instrument that has been ratified by the member state involved in the matter. So that apart from the continental instruments, the African instruments, there's also a whole load of international instruments that become applicable through the work of the court. And that will include the UDHR itself, the UN Refugee Convention, there are a number of conventions on refugees. The International Covenant on Civil and Political Rights, International Covenant on Economic, Social and Cultural Rights, and any other human rights instrument ratified by respondent states. So in normative terms, the framework is quite solid and it is quite broad and almost universally encompassing. At the regional level, when I say regional level, I'm talking about West Africa, East Africa, Central Africa. I'll start with the Treaty of Lagos, 1975, by which the ECOWAS came into existence. And this Treaty of ECOWAS was revised to restate and expand the fundamental principles of the Lagos Treaty. And it was done for better promotion of regional trade and to express very, very clearly the acceptance that you cannot have sustainable regional trade. You cannot have it within your intra-regional commerce and all that goes with it without the protection of human rights. Because if you know your human rights are not going to be respected in the domain, why would you trade into that area? So this article reiterates recognition, promotion, and protection of human and people's rights in accordance, and I'm quoting, with the provisions of the African Charter, and establishes the Community Court of Justice. So within the ECOWAS system, they also have a judicial mechanism, which is the Community Court of Justice. And the Community Court of Justice has a mandate to enforce human rights within the ECOWAS region. And very interestingly, by a supplementary protocol in 2005, individuals were granted direct access to the community court. The problem with some of these regional courts and continental courts is that sometimes the access has to be through maybe a commission. For example, the Inter-American Court can only be accessed through the Inter-American Commission on Human Rights. And to a very large extent, for most Africans, individual access even to the African Court on Human Rights will have to be through the African Commission on Human Rights. It's for you to make your application to them, for them to accept that you have a case, and for them to make a recommendation to the respondent state, and if they don't follow up on the recommendations, for them to then bring the case before the African court. There's also there is the Southern African Development Community Treaty, which sets up a regional arrangement in Southern Africa. And by its terms, the observance of human rights, democracy, and rule of law are also placed in a central place. The unfortunate thing with the SADC court is that it started off being quite a dynamic court, and under the community system they had a tribunal, and that tribunal was taking cases from individuals against their state and so on and so forth, quite successfully till 2010. It was suspended when it made certain decisions against Zimbabwe, the government of Zimbabwe, and in execution of the judgment, because the judgments of in that case was enforced, was brought before the South African courts for enforcement, and then South African courts enforced it and sold some properties of the Zimbabwean government. And you can imagine, unfortunately, that the heads of states within the region were not too happy with the outcome. So since 2010, it has been suspended. And although in 2014 there was actually a protocol to do away with the tribunal altogether, and it was signed by quite a number of the member countries of the SADC. And so some citizens of Tanzania and South Africa sued their governments that no, you have obligations under the SADC agreement to to protect human rights. You have obligations under the African Charter on Human and People's Rights to protect rights. So why are you doing away with the regional court, which has human rights jurisdiction? And they, in both cases, were successful, except that in terms of treaty law, once that protocol was adopted and ratified, these were domestic decisions, so they are good for academic discussion, but they are rather anti-thunder. And so, for all practical purposes, the SADC tribunal is defunct. And then there is the East African Community Treaty. Now that court, that treaty also sets up a court that has human rights jurisdiction, and it's a very lively and active court. And there is also the COMESA court, which is purely a commercial court for trade within East and Southern Africa, but has central provisions that also recognize and protect human rights, so that in cases between states, one state can actually accuse another state of not properly enforcing or protecting the rights of other people. Now, I've already hinted that most of so we have the normative framework, which is really good. And when I used to have to give talks about just the normative framework to non-African fora, I spoke with a lot of pride. But when it came to and therefore the enforceability of the decisions of all these various bodies, then the bragging got a bit more quiet. But because, for example, in the African Charter or in the protocol setting up the African Court, there's a clawback clause which says that for individuals to be able to access the court directly without having to go through the African Commission, their country should have, the country against which they are bringing the action should have made a declaration, a prior declaration, that its citizens and its residents can come directly against it. So the African Court has been in existence since 2006, I believe, and unfortunately, up to now, only 12 states made the declaration. But when I was doing my updated research last week, 4 have voted on their declaration. Ghana the Ghanaian declaration still stands, but Tanzania has withdrawn, Benin has withdrawn, Rwanda has withdrawn, and one of the North African countries has also withdrawn. And so, when we're talking about the enforcement of human rights in Africa, there's always this enforcement gap. The law is there, very beautiful, and set up, and then even institutions get created, but to put teeth into what they do becomes the other problem. And yet, when you read everything from the AU strategic plans, from all the declarations that over the years, human rights is always important. Continental trade is important. NEPAD Now there's what? There are all these regional unions, all centering human rights. But the enhancement of African, inter-African trade, the enhancement of regional trade and commerce through judicial enforcement of human rights, which have been enshrined in the various constitutive instruments. You can see that by and large, they are more talk rather than real action. But the important thing is that where they have established judicial institutions, those institutions, the ones still existing, do exist. And I think after the SADC debacle and the international backlash, I doubt that, for example, the ECOWAS will walk back with the powers and jurisdiction of the ECOWAS court, for example, or that the East African community will do that. So the law is there, the possibility is there. It is the use of it that matters. And that is why a public lecture like this is important. If not for no reason, but for the awareness raising, that these roots are there. And then we get to learn more about how you can access. When the African Court of Human and People's Rights was first set up, I think, my memory fails me, old age is catching up with me. There were about 4 countries that had made the declaration. And so what we used to do, and they still do, is that every year there will be at least one session in a member country, and then it's not only for sitting as a court there, but also it's for doing PR and self-marketing. It took a lot of discussion and hot arguments for the first court of which I was part, for us even to come to the agreement that a bunch of judges of a court can go to another country to go and sell the existence of their court. But strange situations do breed strange solutions. And that method has become quite accepted by the summit of the heads of states of the African Union. And so they do go, and there will be all kinds of nice declarations and assurances. But so far, as I've said, now it is 12 minus 4 that have made this declaration. But the court does exist. And the ECOWAS court is very busy, and it does a lot of cases. And the East African court is also very busy. Now, the other bodies that can also access the African court are what they call relevant non-governmental organizations which have observer status before the African Commission. And there are quite a number of such NGOs, and they can also access the African court. Now, I have to jump because I want to finish quickly so people can have time for questions. There's a whole load of hopeful activities, hopeful instruments within the African Union right now. Even within the Constitutive Act of the African Union, there is established on the paper an African Court of justice and human rights, which is supposed to merge I need to walk it back. It establishes an African Court of Justice. And then subsequently, it was decided that why have the African Court of Justice and then have the African Court on Human and People's Rights separately? So there was a protocol to merge those two bodies. And it was one of those sort of protocols that when I read it was adopted in 2003. It was I found it so amazing because it seeks to create a court of arbitration, a court of justice, so it's something like the International Court of Justice, something like the European Court, something like the European Court of Human Rights, all in one jurisdiction. And so it was so great. And the jurisdiction covered even environmental crimes and corporate crimes, so that the galamsey, that the companies that get involved in ruining our rainforests and our rivers could be brought before this court. Unfortunately, that instrument, all these new instruments are not in effect yet, because the requisite number of ratifications, 15 states, that's all, have not been, the number of ratifications have not been received. So these laws are pending, and it will be good for the Central University Faculty of Law to adopt this kind of issue and to be espousing it and shouting about it and asking why hasn't Ghana, at least Ghana should go and ratify, we counted, but it has not happened yet. Okay, so briefly, that deals with the continental and the regional level. But I have a section which I call Opportunities for Equitable Transformation. And that's where I bring all this to the domestic level. Because practically every constitution in Africa, because as I said, every African country, every member of the African Union has ratified the African Charter on Human and People's Rights. And therefore, there are certain things that must be evident in how these member states do things domestically. And so, if you look at the provisions on the fundamental human rights in our constitution, they're quite extensive, and a lot of it is from the Universal Declaration and from the Charter, and we have also added and improved on some of these. And my favorite article in the Ghanaian Constitution is Article 15. Just a minute. It's in Article 33.5, which reads, the rights, that's the last provision under the fundamental human rights. The rights, duties, declarations, and guarantees relating to the fundamental human rights and freedoms specifically mentioned in this charter shall not be regarded as excluding others not specifically mentioned, which are considered to be inherent in a democracy. That's very broad. And intended to secure the freedom and dignity of man. So it's very broad. And I always like drawing attention to this provision because it's a provision which I would like to see further developed through case law. Because so long as you can establish, that's in my view, and we've applied it, we applied it sometimes in this report. So long as you can show that there is an international convention, so long as there's an AU convention, there is, everybody knows by this principle, this standard, if you can establish it. The fact that it is not written in black and white, it will be captured into the spirit of our Constitution. Because as Justice so has said, the Constitution has its letter, but it also has its spirit. So, in terms of enforcement of human rights, as I said, in every African country, including those who we think are not Dark Salaf, all the same, if you look into their constitution, you will see principles governing human rights. And therefore, in our country, we need to offer let ours work. I know that sometimes human rights activists seek to drive human rights into ridiculous extents, but then the African Charter itself does something, because you see, the African Charter deals with human and people's rights. And it also, therefore, takes cognizance of who we are as Africans in contradistinction to other people. There are so many things that keep us together that are rather ripping apart other societies. And in the African Charter, we are also called upon to make sure that we protect those kind of keeping the family together, the sanctity of family, the family values, social values, and so on and so forth. And sometimes I ask myself, we have all these things, all these standards, all these potential treasures that on which we can grow as a nation and make ourselves special and distinct, and other people will copy us. But we don't work it. Laws, there are many laws, but they will remain on the book, and it will be ink and paper. And sometimes the cockroaches will mess up the paper. These days, thank God, we've got some of all of this in cyberspace, but somebody can hack into it and cripple the whole thing. Let's work it. Let's, you go to court to test the water. You may or may not win. Those who teach law, teach your students to go beyond, is it written there? And let's now be looking more to the spirit. We have a lot of provisions in our Constitution which are yet to be brought fully into effect for people to feel the difference. Then we've had a marriage act, that act, its name keeps changing, and it's been debated in Parliament for decades, and it's still there. And everybody is afraid, the inheritance law. Everybody is afraid of going all the way out. Not because there's anything extraordinary about it, but because it is trying to enact into established norms, certain things that already we have to take into account when we're making our wills, when we're thinking of what's to happen to our children and our families and so on and so forth. So I am one who always, I like at a forum like this to encourage activism, positive activism that will help to grow our law. Having it all on the law books and it's not in effect, it's neither here nor there. It's beautiful. You can show off with it, but when you get to the ground, you don't find it there. And then it is not a living law. It is just a law. And then people will insult the lawyers and say they are wrong. Okay, so now what will be my conclusion? My conclusion, I think I've already started concluding, that let's work it. Let's work all the all the opportunities for enforcement of human rights. Let's become more familiar with it. Let's become more active with it. Let's develop them further, because there are other kinds of, for example, right now, with I'm sure somebody is recording what I'm saying. What are my rights in that recording? The person is recording. All these rights are always evolving, and whenever there are things that happen in human society and become a human norm, straight away you need to start looking at its implications on your rights, on my rights, and then the rights of the group, because they don't always go together. And that is where it is through positive litigation that we come to solid grounds for enforcement of human rights. So Africa has a whole gamut of human rights opportunities. It is the seizing of those opportunities that are wanted. And as for the nations give and then they claw back. Politicians give and they claw back. When it sounds good, they'll do it. There was a period in time when it sounded good to be very generous with human rights, and then they started clawing back after the Arab Spring. And it's been, for me, it's been rather sad and going more and more backward. But we, the people of Africa, are also there. And those teaching the next generation of Africans, let's put some boldness and some start into people's groups. Thank you very much. And God bless Africa and God bless Ghana. So if there is still, I'm sure I'm not way over my time. So if there are any questions, if there's anything somebody was hoping I would say and I didn't, if they ask me and it's relevant and it's okay, I will answer it. If it's not relevant and it's not okay, I will not answer it.
Please, we can give another round of applause. Thank you very much. Ladyship is ready to take a few questions from the audience. You raise your hand if you have a question, and the microphone will be given to you. Law students, it's a beautiful lecture. Ask questions. Ladyship will take about 3 questions at a time, and then we move on.
Hello, I am Daniel. I just wanted to know, I believe human rights goes with governance, as you said. indices or elements that will let you know that there's a good governance within a country? I just want to know what are the, let's say, what are the elements that, let's say, somebody want to, if you talk about good governance, and I would just want to know some of the indices, what are the things that will let someone see that there's a good governance within the country?
Okay, good governance, that's another broad area. But good governance means you have clear laws, you have known processes and procedures, and the human rights are protected and promoted. And above all, you have the rule of law. That without the rule of law, you don't even have governance, let alone good governance. If it's each for himself, God for us, or the devil take the last, you don't have good governance. Good governance is one of those, it's become a catch-all phrase. But good governance has so many elements to it. For example, a country where there is no certainty that once you've won your case in court, you will be able to enforce that judgment. There's an issue of good governance arising because you have your judgment in hand. The judgment is supposed to be executed. If you cannot go and execute it peacefully, what will happen? Then you end up with self-help. And when there is a lot of self-help, land guards and all that activity, it's an indicator that something is missing. And in my view, most of the time, it is because it's the enforcement. So by force, people are going to enforce rather than go and use the state apparatus, the preset system to bring into execution, into reality, your judgment which you have won. This is just an example I'm giving because, like I said, good governance is an area where, unless we are targeted, I find it difficult to talk about it. But I think the basic elements are what I have mentioned.
We'll take a question from the front here. Oh, okay, we have the mic already, so please go ahead.
For his record, I want to add that what is meant by rule of law and what are the essence or importance of human rights?
The essential elements of human rights. Is that what you're asking?
The essence of human rights or importance.
Is it you want to know what's the essence? The essence being what? Its importance, its relevance, its use. I don't understand.
The importance. That's the essence of human rights.
The essence of human rights. There's a whole chapter in our Constitution that sets out human rights. I mentioned some of them. Access to courts of law without a hindrance. Your right to in a criminal matter to representation of your choice. the right to know what you've been charged with. There shouldn't be every crime that anybody can be charged with should be pre-existing. Its criminalization should be pre-existing. You don't make up the criminal law as you go along. You don't like so and so, so now you're going to pass a law to make what they did yesterday a crime, when yesterday it wasn't a crime. That sort of thing. Am I answering your question? You know, I would rather recommend that you go and read your constitution, and you will get a lot of knowledge on that. Because in addition to even the right, some of these basic rights, there's the right to information, the right to livelihood, right to, now these days there's also the right to environmental, to safe water, to safe access, and so on and so forth. So if I were going to list it for you and explain it all to you right now, I think I will be taking up too much of the time. The most important thing is equality, access to justice. Basically, that's about it, and the right to life. But it is more than these. Have I answered your question? Okay, let's
say from Susan.
Thank you very much. Your Ladyship, my question touches on challenges and the prospects for the future. So that was a very insightful discussion. I'd like to know, beyond the lack of political will on the part of member states of the African Union, are there any challenges in the enforcement of the rights of Africans? And then also, what are the lessons for the future that we can gather from the past? Thank you.
I mentioned enforcement even in the domestic level, but even when you go to the extent of setting up a continental court, and as you all know, for those of you who are lawyers or law students, you know that adjudication is not the same as enforcement. You can set up the adjudication process, but when judges finish and render the judgment, that's the end of the work of the judicial system. The rest is the execution, and that is when one needs a way of executing. One of the biggest challenges of the African court, when I was there, and I think it's still a challenge, is enforcement of its decisions. And I think they are still making proposals to the African Union as to how best to go about it. Because as far as each nation is concerned, even though they are members of the African Union, even though they have ratified the court protocol, most have not done what is necessary domestically to even enable the deposit of a judgment of the African court in their system so that it can be enforced. Now, it's a problem with the American courts as well. And there was something we borrowed from them, which was that twice a year, when they meet, when the summit, the union meets, the court has to make its report. At first, we were reporting on our finances and we don't have enough money and so on and so forth. But then when we started making decisions, we started reporting on our decisions too. And so this country has, as soon as we notified them of the decision, they have complied. Or this other country, we will name and change. That's about the best thing to do, you know. And the same name can come over and over and over again. And of course, what they will say at the end of your report is, oh, okay, so we call upon those who have not been compliant to try to be compliant, and then that's about it. But in international bodies like the African Union, that is what happens. That's where political will, that matter comes out. They're never willing to set up the proper mechanism whereby they clearly state, and that was what was in the SADC, the document setting up the SADC tribunal. They actually worked out also how to enforce the judgments of the SADC tribunal. That's why the people who won the cases against Zimbabwe knew exactly where to go. You deposit it in the South African court system, and then it is enforced like a South African court decision. But we have this dualist system in a country like Ghana, where even a foreign judgment, unless there is a certain agreement between the country and this particular country, a judgment from that country is not even enforceable, and so on and so forth. So there are all these enforcement gaps, and maybe one thing, I'm setting Susie an assignment for her students to identify as many of these enforcement gaps as possible and come up with suggested solutions. Because sometimes it is from academia that sound solutions can begin to percolate. What was the other part of your?
The other part was on the lessons for the future. I believe you touched on something.
Lessons for the future. Yes. Human rights law is not some arcane part of international law. First and foremost, human rights law is cross-cutting, and the protection, promotion, and the observation of human rights has to be evident in everything that we do across the board. And it cannot be, it's not really a specialist subject, because it affects each one of us. And every time we transact with each other, we are either applying or not applying human rights. And when we're thinking of what the observation of human rights and the respect for human rights can do for us in our nation, we have to think of how important human rights law is for national development, for peace and stability, for all the sine qua non matters which will make life unlivable or unpleasant or brutish and short in the absence of human rights. You know, I've listed some things, and they have nothing to do directly with human rights, but the human rights impinges on it. And if it's not seen as a right, or from a rights standpoint, then we miss the point. For example, ensuring democracy and stability. Period. Because political strife will not enhance or assure human rights. Food security. You know, it's funny. This part I copied it from an old presentation I made, but it's so today You know, and then another very important thing, strengthening regional integration, because regional integration enhances mutual human rights across the region, enhances, and then whilst enhancing human rights, it's also enhancing regional trade, interregional trade. There's so much we could be trading among each other. There is so much we could. I once saw a certain map. I think it was the African. They have to do with social and political matters. It's one of the agencies of the African Union, and somebody from them showed me a map where somewhere in the early days of the OAU, Africa has been mapped out, and then in terms of agricultural produce, and that this country is best for this produce, that country is best for this one is best for that. So that in the end, we're not trying to grow wheat in Ghana, where maybe it rains too much or it doesn't rain enough. But some other country, you just throw them even bread and it starts sprouting wheat. So that's another level of cooperation, and that's another level of assurance of food security. And food security also lies at the base of stability and peace. So, and then, measures to promote how can we use all of this assurance of human rights going forward? What should we do to promote social cohesion? Africa is stronger when we work together. And the things that we have successfully done together, and even on a regional basis, the things West Africa has successfully done together, we did very well with it. And there was a time when we were moving onward and upwards, and we need to catch that momentum again. And it's not so much conferences and talk. It's real action. That's what we'll do it. And then also at the base of all this, harmony. Harmony is very important. Harmony among people, because people vary. And then religious harmony. Ghana, somehow we've been very successful with that. And every day when we say our prayers, we should thank God for that special thing He's endowed us with. But look at what religion is doing across other parts of Africa and other areas of the world. And we cannot, as a people, continue like that. We're here to exist and exist in a way where it's not from hand to mouth, or you're wondering where you will see tomorrow because you're on the run. And all of this is important, and the respect of human rights is important. Do you think that those who are polluting our waters, they were really human rights because they were doing what they are doing? No, they're just looking at their rights. But as in the law of talks, your rights and where mine will be. So let's work together. So if everybody will be enjoying their rights in an equal way for the sustenance and the assured survival of the greater whole. Because if you, as an individual, you survive, and I, as an individual, I survive, but our society has not survived. Did we survive? No, we did not. So, if there are no more questions.
The leadership has been on the feet for quite some time now. I'll take two more questions from the audience. I'll get into the law students. thank them. Let's hear from him. And I would like to hear from one law female student. If there's anyone here who is prepared to ask a leadership question, I'm very grateful. So, after you, we have a lady or a law student who would like to ask a question. Then I'll probably get him on the Q&A.
Thank you. Thank you for the opportunity. My name is Albert. I would like to know the distinction. I would like to know the distinction between human rights and people's rights.
I was wondering when that one would come. Okay, now, basically, human rights are the individual rights, the rights that each individual came into the world with. But there are also group rights. And particularly at the time the Charter was adopted, most of Africa was still under colonization. And so, they are including, so that the rights like the right to be free, the right to self-determination was included in the Charter. Because everyone was born free, and somebody cannot come from their continent and say that I really, when I didn't have a say in it. So the right to democratic governance is also part of people's rights. Individual rights is contained in it, but it is also a group right. And I'll give you a very good example of people's rights that came before the African court, before I left. In fact, I think it was the last case we didn't even complete it. I was the rapporteur, so I did the report, but it was completed after me. And it was a matter that came through the African Commission, the Bantu Commission. And it was a matter concerning a group of people in Kenya called the Okieks. It's a tribe. And they prefer to continue to live in a natural way. And so there was a whole area made up mostly of forests. And that's where they lived. They were forest people. They had developed their own rules on how to continually eat from the forest without destroying it, so that it would continue to provide for them. And so they were not even encouraging going to town and bringing back some bottles of cans of Red Bull, which you would throw under the forest somewhere. But very peaceable people, minding their own business and making their tribal observations to preserve the forest. And then the government marked out certain parts of the forest. And initially they said it was a forest reserve, and they said, what reserve? We are preserving this thing we want to preserve. So we don't understand. So they started their action, and while the action was on they sent their complaints to the commission. And whilst the commission was, it takes time, they were doing their investigations and all that. Then they started subdividing for estate development, factories, this, that. So they brought a supplementary matter. And in the end, the long and the short of it was standing one. And the court decided that as a people, they have a right to wear leaves, and they have a right to live in a particular lifestyle within the forest. They were not harming the forest. They had lived like that and in that spot for generations upon generations, countless. forced any harm. So you can't, under the guise of forest reserve, nobody can love that forest more than the objects. And so they won. And that was a protection of people's rights. It was not any individual's right. It was for the rights of the people, the object people.
There had been one of the problems of human rights in the future is gender equality. Now, we are talking about enacting laws for women's human rights or human rights towards the woman. How do we bring the two? When men, there are no, human rights directed towards men. However, there are human rights laws that are enacted towards women. We are talking about gender equality. I want to really understand how we can, couple the two. I don't know how that works. I don't know whether I'm making sense.
I think so.
Thank you.
In other words, what about the men's rights whilst we're talking about human rights, right? Yeah. And really what we should be talking about is gender equity. And there are so many instruments that deal with equity. See, when you're engineering, let me just use that word. When you're engineering human rights or the rights of people, you must, at the end of the day, be able to look and make sure that nothing that you put there works so much in favor of one that it goes to the disadvantage of another. Yes. And that is why, for example, in working on matters concerning the rights and welfare of the child, if you remember, there used to be a lot of emphasis on the girl child. As a result of it, of which the boy child was sort of forgotten. But now, the way it's done is you analyze it. At what point is the girl child more at risk than the boy child? At what point are they all at risk? What are the risk factors? What interventions? So that you're not looking at catch-all and everything. So something like the African Charter of Human and People's Rights captured everybody. But in the end, the men were enjoying more than the women, in the sense that there were a lot of practices that were being respected, that were being protected, which, when you look closely at it, worked against the interests of women, or of women of deprived social background, and so on and so forth. Because the goal is equality through equity. So you need to focus on getting the equities right. Then you will get equality, right? So that's why you should read the Women's Protocol, the African Charter, the protocol to the African, blah blah blah, on the rights of women, and you will realize that they are picking on specific things, specific practices, specific activities, specific situations that weaken women and make it difficult for them to enjoy the rights under the African Charter on Human and People's Rights. Yes. So we should never forget the equity aspect of it. Although I know in the law of equity it says what equality is equity. I think equity is equality. That's really important.
Thank you very much. Please, you can do it better than this. Thank you very much. Thank you. I know that there are a number of people who would have liked to ask questions, especially when you are at a lecture and the lecture is excellently executed. You would like to ask more questions, but you know we have to stop at a time and at least bring this lecture to a close. At this time, I'll ask the chairman to give his closing remarks. Professor Blanco.
Your Ladyship, thank you so very much. This has been an engaging lecture, and I have learned a lot from listening to you. On the sheet, it says announcements. The announcements will be made after. Oh, thank you. Well, Your Ladyship, thank you once again so very much. This has been very, very insightful, and I have learned a lot. As the law students will realize, I'm wearing the trousers that lawyers would like to wear, pretending that humble psychologists can begin to look like a lawyer. But as I've also found out many times when my students are 200 and they begin to act as if they are lawyers. And so tonight, as I have sat at the feet of the Ladyship, I can begin to think that I am approximating a lawyer. I have come away with a number of very clear points in my mind. Firstly, that rights are not given, we come with them. And I think that's an important point for all of us to take away. That they are not given, we come with them. Therefore, it's incumbent upon us to reach out and, as it were, grab those rights by whatever means legal necessary. I note also, Your Ladyship, and that's so very important for us, that rights are fundamental to everything that we can achieve in society. And wherever possible, let's learn to, through advocacy and through testing, push the boundaries of these rights. And that is very, very important. And I really want to urge the faculty of law that we impress on the students we are training that apart from litigation and all the rest of it, that they can do right by us, to test the law, to take cases to the courts, to the Supreme Court, I believe, for interpretations and for expanding the boundaries of these matters. I will simply end by saying that being law, I think you have your work cut out for you. The Ladyship mentioned a number of different areas, such as the hanging charters, the gaps in enforcement, and the whole area of rights, human rights in Africa, which really can be tackled in the classroom and tackled as clear areas of specialism that we can come up with. And I'm grateful to you, Your Ladyship, that you saw fit to encourage us that in forums such as this, we do right by society. Thank you very much. We look forward to perhaps welcoming you once again at another forum. I forgot to add, ladies and gentlemen, that the Ladyship is also the chair of the Council of University of Ghana. So we have the whole chair of the Council of University of Ghana here. as we have the chair of our own council, Madam, for the discussion. Thank you so very much. We look forward once again. Welcome. Very, very grateful to you. Thank you.
Thank you very much, Mr. Chairman. The next in our series of lectures will be on the topic New Paradigm for Public Sector Compensation, a restatement. And this will be given, the speaker will be Professor Philip Ebo Simpson, former rector, Gilbert. The date to be announced in due course. At this time, the Faculty of Law would like to make a presentation to her ladyship.
Thank you very much, ProVC. On behalf of the Law Faculty, on behalf of the lecturers, the students, and our Dean, we would like to present these gifts to Her Ladyship, Justice Sophia Akuffo. We are so grateful to you for accepting our invitation. We are honored, and we have drunk deeply of your knowledge this evening, and we give you this as a token of our appreciation.
Thank you very much, Faculty of Law. Thank you very much. All too soon, the program is coming to an end. We started with prayer, and we would like to leave here with a prayer and a blessing from our dear Lord. I'll call upon Professor Adel Kastner to give us the closing prayer.
Shall we rise to our feet and pray? Stretch our legs a little bit. Yes, I like this institution because in other jurisdictions, normally starting programs with prayer, closing with prayer, really this gives it a special spiritual touch. And I know that Her Ladyship, Justice Akuffo, appreciate that. Of course, she's one of us. Shall we pray? Dear Heavenly Father, we thank you all too soon. We have come to the end of this insightful public lecture, so well delivered by Her Ladyship, your daughter, on the enforcement of human rights in Africa. Our Lord, my God, we know that you gave us rights, even from the point of birth. You even respected our will, and you gave us opportunity to make our own choices. Lord, many a time our rights have been trampled upon. Today we have heard a lot in where the gaps are. We pray that you energize the legal fraternity, especially those in academia, to take up the challenge. The battle is yours, Lord. As I listened to Her Ladyship, and she talked about the rights of of women. And sometimes the way we respect the male counterparts, but sometimes, Lord, it is as if the women become lower beings. Lord, we pray that this insightful lecture will energize society so that we will have light at the end of the tunnel. That Ghana will stand tall among her peers in Africa. That it will be said that we respect human rights. Rights of everybody. Individual rights, rights of groups will be respected. So that together we can build a better nation and be the beacon of hope that is expected of us, even in Africa, particularly in the West African sub-region. We thank you so much for our Vice Chancellor. We thank you so much for the life of our Council Chairperson, the good work that they're doing, and especially the Dean of the Law Faculty in Central University. Lord, my God, we pray that progress will be our portion, advancement will be our portion. We pray that, Lord, we'll break new ground in academia, and your name will be glorified. Thank you even for the life of the Chancellor and those whose names I cannot mention at this point in time. May your grace attend us as we travel back to our destinations, and may everything that we do bring glory to your holy name. We thank you. In the name of our Lord and Savior Jesus Christ. Amen.
Thank you very much. On behalf of Central University, I would like to thank you all for coming. We look forward to seeing you at our next lecture. Have a pleasant night. Thank you.
On destiny's heels to where